Fantastic. Thanks, Dave, and thanks everyone for being with us today, and especially to our unbelievable panel of experts. I'm joined today by Emily Bell, the founding director of the Tao Center for Digital Journalism at Columbia University Graduate School of Journalism, by Adam Goldman, who we were just chatting before the panel, has as many phone record seizures as Pulitzers, 2 each that we know of. He's a reporter at the New York Times where he covers FBI and national security. Bruce Brown, executive director of the Reporters Committee for Freedom of the Press. Jane Kirtley, the Silha Professor of Media Ethics and Law at the Hubbard School of Journalism and Mass Communication at the University of Minnesota. And Mickey Osterreicher, the General Counsel for the National Press Photographers Association. The common thread that ties all these folks together is expertise, scholarship, and real-world experience in this complicated intersection of the press and the law, and in particular, the really hard line-drawing question of who the law does and should count as the press. The baseline of all of these inquiries that Dave was discussing really is this shared one, that there is such a thing as the press, or at least an identifiable set of press functions, and that preserving some rights for the press separate and apart from those enjoyed by all speakers is valuable and constitutionally envisioned. We have a big panel and a relatively short amount of time, so we've decided to do our best to try to capture some of the major themes that we think are most timely and helpful to this audience. I want to ask a couple of questions that are focused on broad principles, each followed by some questions that give us a chance to burrow into some illustrative examples where our panelists have real-world experience. We're going to first explore the sorts of spaces where unique press-specific protections could be particularly warranted or valuable, and then, operating on the assumption that those protections are worth seeking, ask about the complexities that arise in the definitional line drawing. Okay, so let's dive right in. Let's start with the broad principle. Bruce, from your perch at RCFP, what do you see as the most important unique rights that the press clause should be seen as protecting for those performing a press function, sort of distinct from other actors or speakers or publishers?
Right. Thank you, Ernell, and it's great to be here with everyone. I thought I would briefly just first highlight a couple of the contexts in which this issue has come up in our work at RCFP in the last couple of years. There's the DOJ guidelines that I'll be talking about a little more later. There's the protest and the right to record cases. I know that Nikki and others will cover. The January 6th cases have already started to produce some questions around this. We have people on the RCFP board who've been covering the insurrection, and then they call me and they say, the guy that I tried to interview about January 6th told me that he's a reporter too, right? Driving our board crazy. So we're getting it there as well. Interesting case involving John Schroyer, an InfoWars host, and magistrate ruling in the DVC that I may get to later. And then finally, in this sort of not surprising area over the last couple of years, the rabbit hole of Julian Assange and WikiLeaks has kept us very busy at RCFP. But there are some surprising places where it's come up too, and I just wanted to highlight a few of them. During the Apple FBI case a number of years ago, RCFP was scrambling to see if we could file on very short notice a news media amicus brief in that case. And there were a lot of questions about whether reporters are just like any other users of cell phones. And we really struggled with that question, and there are a number of reasons why, given the timing, the posture of the case, and so on, we didn't get to an amicus coalition in that case. But that was a really troubling question that we were struggling with. We've also had in the last couple of years a case involving impersonation by the Justice Department of an AP report, right? So if the Justice Department is going to great lengths to impersonate a member of the institutional press, then being a member of the institutional press must mean something to DOJ. Dave, a few minutes ago, noted licensing questions that came up during Brandsburg. We've now had the very peculiar posture in the Index newspapers case of having RCFP file an amicus brief saying the judge should not tell the ACLU to choose who is a journalist and who is not a journalist, right, for the purposes of getting protection to cover the protests in Portland. And of course, Ronell, there have also been the interesting platform examples that RCFP has been a part of, the right to be forgotten, where there is a distinction between the processing that search engines do of personal data versus the processing that the media does of the same data. When we did a media coalition in the B and Cardi case that's pending now in the European Court of Human Rights, we of course played up, the institutional press role, as we did in an amicus brief we filed when the president sought by executive order to shut down TikTok and WeChat in those cases. Of course, the government was arguing that regulating commercial transactions doesn't implicate the First Amendment at all. When we were figuring out, well, how do we attack that if the shutting down of a platform ends up having a profound effect on expressive freedom, the metaphor or the example that we decided to give in our brief, it won't surprise anyone, I'm reading from our brief, we said that if prohibiting an app store from hosting TikTok is analogous to allowing an American reader to subscribe to the London Review of Books, to prohibiting any shipper from delivering it to that person's doorstep. Of course, we wanted to pick an example from the professional publishing world rather than just the mere speaker, because we thought that would be effective in that case. And then in terms of the arguments we're making in these cases, you won't be surprised that RCFP, of course, is focusing on the press, institutional press as surrogate for the public. You'll see a lot in our briefing. Here we are at Yale, the old Potter Stewart of the press formulation. We talk a lot about autonomy of the news media as an institution. I do wonder, just in closing my answer, whether we in this area will find ourselves increasingly now focused on questions of integrity, editorial integrity, professionalism. The Thomas Gorsuch critique of New York Times versus Sullivan, where it kind of boils down to, well, it's all just content. You're all in the same boat, and the standards of editorial professionalism have really diminished. Very interesting, Ronell and Sonia, of course, for your study of the way that the Supreme Court writes about the press. I know your study came out before those decisions came out, but the way they write about the press, I guess the only thing you can say about it is it's a little better than what Judge Silverman had to say, where, for him, it's not just all the same slop. He says it's all biased anyway, right? And that's why New York Times versus Sullivan needs to get re-examined. And so I question whether we have in front of us a project of now needing to defend Sullivan from the perspective of the institutional press. And I'll just close by saying at RCFP, we work a lot with the institutional press, of course, but we work a lot with freelancers, and we work a lot with very small newsrooms and nonprofits. And so when a question like that comes to us, we know we have to defend on one flank without giving an inch on the other. And that's challenging.
That's super helpful. Thanks for that. Mickey, it seems like there are some really important lessons to be learned from the recent police targeting of the press in protests and unrest. What do you see as sort of the key takeaways about press-specific protections from those examples?
Well, the protests this past year, 18 months, along with COVID, really point out the importance of at least visual journalists. And nowadays, it's not so much even that division of visual journalists, because pretty much everybody's got a cell phone. Every cell phone has a camera, and young reporters are being sent out with the same equipment as other journalists, and are recording. And that whole idea, I mean, we've been working on it for so many years in trying to establish that right to record on the street, because it's so important in terms of You don't have that he said, she said, this happened, that happened. Somebody is trying to relate to and explain what happened. You're able to literally show and hear what happened at those events, how the police acted, how the protesters acted, what the situation was. So that's so critical. And we've been working on that for many, many years and had established that right being clearly established, as it turned out, in all of the odd numbered circuits in this country. The Supreme Court has yet to rule on that. That may change very soon. So the 10th Circuit had a case. It wasn't a press case. It was a matter of a gentleman who saw the police very much like Darnella Fraser with George Floyd, who stood there silently and just held her camera and recorded. But for that recording, and there were other recordings, the police body cams and so forth, we might not have known what actually happened on that day and how long things took and what that actual sequence of events were. But in this case, another Fraser, by the way, Mr. Fraser in Denver, was recording police trying to effectuate an arrest, a drug arrest, and they were, at least from the video and what was reported, beating the subject. And when he was done recording and they were done arresting the other person, they wanted to get rid of that recording because they didn't want it to be evidence of what they had done, and they retaliated against him. He brought the 1983 action, and because the right isn't clearly established in the 10th Circuit, the court, the district court, gave the officers qualified immunity. They'd also brought him an L claim, his failure to train and supervise. And at that point, those very same officers that got the qualified immunity because the right wasn't clearly established testified and said, no, we've been trained. We've got a policy. We know what the policy is. We know people have a First Amendment right to report. At which point the judge said, wait a minute, time out. Can't have it both ways. And he brought back he took away the qualified immunity, at which point the Denver police appealed, and it went up to the 10th Circuit. And we thought, all right, we're finally going to get our first even numbered circuit to say that right. Maybe it didn't exist at that time, which happened in the 3rd and the 5th, but the court's there, and what we were hoping for the court here to say, but henceforth from this point forward, the right is clearly established. They didn't do that. They kind of contorted themselves into pretzels and basically said, we don't care if the officers have actual knowledge that there's a First Amendment right to this stuff. If we don't say it or the Supreme Court doesn't say it, they get qualified immunity. And the case is now up for cert. The government was supposed to respond as of yesterday. They got an extension. So we'll see what the Denver police have to say on October 7th. Unless again, they get another extension. And the Reporters Committee did a wonderful amicus that was joined in by quite a number of organizations, including NPPA. And we hope, that one, they take the case and think it's important, and two, that they decide correctly and not set back all the work that we've done for, well over a decade on getting this right. Clearly established circuit by circuit. And then it's just so important. I did a lot of training and have done that for years, working with the Reporters Committee and PPA, training journalists as to what their rights are. But as we've seen time and time again, journalists saying, I know my rights, is usually the last sentence they utter before hearing, turn around, put your hands behind your back, you're under arrest, even if they get that courtesy. Because more often than not, as we saw during the protests, they're just slammed up against the wall or down on the ground and handcuffed and taken away. And very oftentimes, they're not even charged, but it's that kind of catch and release. They put them out of commission. They're not able to photograph and record. They're seizing equipment, and that's a real problem. More particularly, what we saw a lot of during these protests is that the police seem to be targeting journalists. If you were wearing credentials, it was almost like a bullseye or a kick me sign. And there were a number of journalists that were seriously injured by police officers using what's known as less than lethal weapons. But when you shoot somebody with one of those less than lethal weapons from a distance that's closer than the minimum distance that they're trained to shoot from. We've seen journalists lose their eyes and be seriously injured, and that is a very serious problem. The flip side of that, dealing with all of this and the government, is the fact that there are more and more people that look at the media as almost an arm of law enforcement, unfortunately, and they don't want to be photographed and they don't want to be recorded because they may be caught doing something that they don't want to be seen doing. And so we're seeing now journalists being attacked by protesters on the left and the right. There's no real one or the other. And then one of the other issues we're going to talk on, but I'll just touch on a little bit, is January 6th, and there were quite a number of journalists there. And as a matter of fact, I've had to deal with the DOJ and the FBI because one of our members actually called me and said, "Mickey, can you help? My picture is on the 10 most wanted list." And he had, they had seen him in surveillance video. If we've all seen that video of the officer that's kind of being crushed and is kind of screaming out, he's got his helmet on, but he's just being mushed against a staircase and the crowd. And the photographer, one of our members, was literally on the other side of the staircase and reported all this. And they thought that, the government thought that this was one of the people that was one of the insurrectionists. And fortunately was able to provide his NYPD press card, show him his work, show him his website, show him out. Most of the people I represent are individual journalists, the independent journalists. They don't necessarily have the support of a big news organization. But again, we're seeing, the government asking for things, and we're absolutely pushing back, saying if it's published, great. If it's not, even though we don't have a federal shield law, go look on these websites, go look at these links. If it's published, knock yourself out. If not, get a subpoena. Especially because we don't want to be seen by protesters as a further arm of law enforcement. I've said it's not the job of journalists to do the work of police. So, we obviously will get into more specifics, but I think that's the general overview we're dealing with on visual journalists being out there and how important that is.
Yeah, that's helpful. Jane, your home state of Minnesota was at the center of a lot of this action in the aftermath of George Floyd's death. Do you have any quick follow-up thoughts to add to this on the question of press-specific protection?
Yeah, thanks. I think Bruce may have been alluding earlier to the Goyette case, which was litigated and arose not after George Floyd, but after an unrelated police use of force incident that occurred in the close-in suburb of Brooklyn Center. And Judge Mimi Wright issued a TRO prohibiting the cops from arresting, threatening to arrest, or using physical force at any person they know or reasonably should know is a journalist. And what she gave is the indications of whether you're a journalist or not is visual identification, such as carrying a professional or an authorized press badge, whatever that means, or other official credentials or distinctive clothing. She said her list was not exclusive and you don't have to have them all. And she added that the police aren't liable for unintentional violations. It doesn't apply if they have probable cause to believe the individual committed a crime. Importantly, journalists aren't required to follow orders to disperse nor subject to arrest if they fail to do that, but they're bound by any other laws. There are some other provisions dealing with seizure of the journalist's equipment. They're basically not supposed to do it unless the journalist is committing an independent violation of the law, and they have to return anything they seize immediately upon release. And if they need to hold it for evidentiary purposes, they've got to give a list, first of all, to the journalist, and then they've got to get a search warrant or subpoena to actually retain that stuff. Interestingly, the state of Minnesota State Patrol, which is one of the named defendants in this case, issued a statement where they had, the obligatory, a free press is foundational to our democracy, and it's really important for journalists to be able to cover civil unrest. They said they'll continue to respect the rights of media to cover these things, and they hastened to say that in the Dante Wright protest, no journalists were arrested. One of the controversial things that had arisen was that the troopers were checking and photographing the journalists and their credentials and driver's licenses, which really freaked everybody out. They said they were doing it to expedite the identification process and then journalists could go about their business. They said this was to move the process along, but now the media have said that they don't like that. The TRO seems to prohibit them from doing that. They said they're not going to do it anymore, but they'll continue to check credentials so media will not be detained any longer than necessary. They also said in a kind of a nasty way that they will no longer include messaging at the scene advising media where they can go safely to cover events. So it's their cute little way of saying, well, if we're not going to be able to have this authority to boss you around, we're not going to help you either. The TRO was extended originally to May 14th. And then in the latter part of July, the parties stipulated that the temporary restraining order would last until the court rules on the pending motion for preliminary injunction. So at the moment, that's the provision we have in place in Minnesota.
Yeah, that I think that case is such a great snapshot of the complicated intersection of questions that we have to ask and answer here. Okay, let's round out this question of what rights might uniquely belong to the press with what may be the biggest development on this in the past year, the changing DOJ guidelines and subpoena protections for journalists. Adam, you've got some important lived experience in this space. What are the best arguments that we should be making about press-specific rights on this front? And I guess also, how would consistency of protection from administration to administration make a difference for journalists?
Well, let's just back up a moment and talk about what happened in 2012 with me when my phone records were seized by Eric Holder, who was then the Attorney General, and the Obama administration. After they seized those records, there was a big kerfuffle and the media was outraged, and they met with DOJ officials, and DOJ said, well, we're going to strengthen these guidelines, right? But we as reporters who deal with national security information knew there was a big hole they could drive a Mack truck through. And then essence was the government said, if there's a national security exemption and we can get your records without notifying you. And we saw this coming. We knew exactly what they were going to do, and they did it. This time they did it on the Trump administration, and in September, then Attorney General Barr authorized the seizure of our toll/phone records last year. And so when that happened, when we were eventually notified of that, it wasn't unexpected. Luckily, Google of all companies stood up and raised their hand and told the New York Times that they were trying to get our emails. And eventually this DOJ under Merrick Garland backed down and didn't pursue those emails. They dropped that. So going forward, what do I expect? Well, if nothing happens, I expect if there's a new administration, let's say Trump comes back and he's there and he's made his disdain from the media very clear, including the New York Times. I would expect that, the guardrails that Garland has put in place not to go after our phone records, and emails will fall to the wayside. And once again, with a new administration, it could be a Democratic administration too. They could go out, they could decide it's important enough to do that. So we would be vulnerable again. One other point I'd make too is, they like to say, DOJ and these federal prosecutors, we're not the targets. They're trying to get the leakers. The leakers are the targets. You know what we are? We're collateral damage, because they run all over us and they run all over the First Amendment. And they know it has a chilling effect on our reporting, and they know it. They do it because they know they're trying to create a deterrent, and they're trying to get people to stop talking to me. I mean, I don't want to be in the newspaper. I want to see my name on top of a story. I don't want to see my name in a news story about being subpoenaed. What do you think sources think when they read that? Well, if we talk to Adam Goldman, they're gonna find our phone records eventually. So that in itself is chilling. I don't know. I mean, I guess you could argue that these guidelines need to be codified in some way, that the next administration that comes in can't do that. I don't, there are, I've thought about scenarios, and I'm not advocating this scenario or not, but what if there's a journalist who is receiving information that's anonymous, right? And let's say this information is devastating to the government, right? I mean, it's literally putting people's lives in harm's way. Like, people are being killed because this information is being leaked to us. And we don't know who this person is. And let's just say, hypothetically, that person is a foreign agent, right? Who's trying to use a journalist to disseminate information that's damaging to the security of this country. Then what? What is the government supposed to do? It's something I've thought about. So I'm not sure, to be honest. I'm not sure if there is a straightforward answer and how to deal with this problem, and that includes, whether we need a shield law or not.
Yeah, that's helpful. Bruce, let's tag you in because your organization has been central to negotiations here. Do you have anything to briefly add about the strategy of bolstering the stability of these protections? Is there maybe as a segue to our next major question that we're just going to turn to about how we're going to define the press, or at least the press function?
Sure, and since I've already spoken, I will just be brief in saying that the guidelines have never defined member of the news media. They're over 50 years old now. And both in 2013-14 and in these most recent meetings with DOJ over the summer, that question has come up. Do we need a definition? And both times, the groups of editors and reporters at RCFP and lawyers for news organizations that RCFP brought into those meetings have said to DOJ, you don't need to define. And strategically, where we were coming from was, we felt that to try to get into a long discussion with DOJ around defined terms, when we're trying to push them quickly towards whatever changes they're going to make. We had this moment politically where we wanted to seize the momentum, particularly with AG Garland. We sensed that over the summer that he wanted action. And to get caught up in a question of defined terms, we thought would not be helpful. And secondly, we felt that it helped us in the long run not to have the term defined, because it placed our advantage. In a close case, we feel that DOJ is going to, give the tie to the First Amendment. That they're going to want to say that they applied the guidelines, even if it's a case where ultimately, they found the guidelines didn't offer protection. They're going to want to say that they applied them. And so the lack of a definition, we have felt, helps us much more than anything we lose by trying to define. Now, before we move on, I would just say we have the Garland memo. It's about 2.5 pages long. It lays out the new flat rule that Adam described, but we are looking ahead to doing regulations with DOJ to replace the regulations currently in place at CFR 50.10. And it is possible that this issue could come back when they do the regs, that they're going to be at us and say, well, we think we have to define it. And I think, again, for RCFP, this process is the ultimate institutional press process. It's like if there were a movie and some grisly AG says, get me the press. The people in that room are the press. I mean, they're the organizations that have most at stake because they are the ones doing the national security report. And so we have felt very comfortable with the organizations in that room being the organizations that really should have the most say in how the rules are ultimately promulgated. At the other hand, as I alluded to earlier, if you're RCFP, you're representing the whole industry. And the challenge, if we get around to a process with DOJ around trying to define this term, is how do we do it in a way so that it's meaningful to the institutional players who are doing the national security reporting, but also in no way undercuts the freelancer, the small newsroom, and others who may at some point find DOJ guidelines are also good.
Yeah, thanks. It looks like a couple of people are having trouble hearing Bruce. I had clarity of audio, but that might be something we want to loop back on. Sorry about that, everybody. But thanks for that. Emily, I want to move to you on our next really broad question, sort of taking as a given that there are some contexts where we need to be advocating for press-specific protections to be doing some heavy lifting. And there's a sort of new wave of scholarship that's suggesting this. Martha Minow from Harvard has a new book sort of advocating an invigoration of the press clause in some specific contexts. There are other scholars, Sonia and I, who have been pushing hard for thinking about the ways that the press clause could be invigorated for news gathering, in particular news gathering protections. Courts are starting to have to tussle with this in a bunch of the ways that we just described. If we sort of take as a background that line drawing might have to happen in some circumstances, and that it would be a good thing for that line drawing to happen in some circumstances, what considerations do we need to be taking into account definitionally? I know you're doing some amazing work at Tau on both the lessons to be learned from platform categorization and on the ways that these definitions sort of have to take care not to sweep within them bad actors. So maybe like, what can you tell us about the value structures that you think are most crucial in this piece of the definitional task?
Yeah, sure. It's a great question. I think, I was just sort of reflecting on what Bruce was saying about, thinking about how definitionally drawing lines can be helpful and how it can be not helpful. And I think that, working in a journalism school, we're very aware that this is a craft, it's not a profession. It gets a little bit of vitality from the fact that it's not a profession. We don't want to see it credentialed, we don't want to see people licensed, but we also see an increasing fraying at the edges, if you like, or people using the vehicle of journalism, the livery of journalism, to do what I would call not journalism. I'm borrowing that phrase from my colleague Jennifer Grigel up at Syracuse, and they say their work very much centers on the idea of propaganda and propagandistic outlets from both domestic and overseas governments presenting themselves as news organizations and journalists. So when you look at the output of something like Russia Today, RT, it looks and it employs journalists, employs people who call themselves journalists. It does the things that look and feel very like journalism. There would be an argument, I think, even among scholars on this about where, and even among journalistic organizations, about whether something like RT should be categorized as journalists and journalism, albeit paid for by the Russian government, or whether it should be paid for, or whether it should be thought of as propaganda. And this idea of what it's almost like if you have these strength and press clauses, do you need something which is more robust about identifying what is not journalism? So without getting into the weeds of, so when you talk about integrity, I mean, integrity is a really key thing here, which is, is there a track record? I'm going to borrow again work of a colleague in the field, Camille Francois, who in misinformation detection draws up a framework which is ABC, which is actors and behavior and content. And what's interesting is that I think to define journalism now, you need to have a clear view of the actor, the behavior, and the content. So, are these organizations, wherever they sit on the ideological or political spectrum, is it there? Are they employed or spending their time as journalists? Is their behavior journalistic? Is their content journalistic? We see all sorts of things now, basically sort of political lobbying campaigns as journalism. That's a very frequent, that's something that our research is centering on at the moment. Does it matter that when I put into Google, it's quite entertaining, I did this with my students the other day, if you put into Google the words Edward Snowden, the research stub that's returned to you is Edward Snowden journalist. Now, Edward would not even define himself as a journalist, but it's something again which in the world of search engines and categorizations on platforms, this sort of principle that I think was articulated a lot in the early 2000s about the great promise of the internet is that anyone can be a journalist. Now it's being codified in very different ways, which include things that are not journalism. So, without, it's almost like being able to say this thing might be journalistic, this output might look like journalism, but this is a political lobbying campaign paid for and operated by public relations operatives, that we've found out where their headquarters are, and we can tell by how they're operating that these are not really what we would call journalistic organizations. They are operating in one plane to achieve, whether it's a sort of an advertising or public relations outcome, whether it's a political outcome, and activist organizations also sort of is an interesting. We see lots of kind of work where honestly the lines are extremely blurred around this. Does that matter so much? I've always been on the side that says those definitions do not matter as much, but now when you see it codified in, for instance, search engines, when you see it codified in the taxonomies of large-scale platforms, when you see it carrying incentives or sort of algorithmic promotion with it, there's a whole field where actually it really does matter, and it matters in terms of, are people receiving good faith reported material? Are they actually reading something or looking at something or watching something which has been generated for a completely different purpose, where actually that's illegible? So I think, and I feel as though we are going to see, I think, more of this rather than less of it, and it also kind of plays into this general degrading of, if you like, the idea of what the press is in the minds of the public. So once you get into this cycle that says, well, you can't believe anything that you see because it may come from here, it may come from there. I think we need more clarity in systems to deliver that clarity. How you codify them legally, I think, is really problematic. But I do like this idea that we can actually identify things and say, well, it might look like this is not journalism. And, the field, certainly sort of, the field of practicing journalists has something to do with that as well. I think, we recognize, and perhaps it is about norms and informal networks as much as it is about codification. But I do think it's a significant problem.
Yeah, I think that's so valuable. The sort of intersections, the interdisciplinary inquiry here strikes me as so critically important, because we have press scholars who are working very, very hard to sort of think through a theoretical model about what counts as the press, right? What is the constitutional press function? And I think your work at Tau really helps us to think about how it's as important, if not more so, for us to think about what isn't, and about the ways that bad faith actors might try to take advantage of definitional schemes. So I think that's super interesting and important to the conversation. Jane, one example that you and others have explored and written about is Project Veritas. And I'm just wondering if you can play out for us quickly sort of how some of these complexities that Emily just raised have manifested themselves in that setting.
Sure. As I mentioned, I posted in the materials a complaint that was just filed yesterday in the Western District of Washington against Stanford University of Washington by Project Veritas. They're complaining that they've been defamed through a blog post, and also through what they claim was a secret conspiracy between this blog post and the New York Times to defame them. In the lawsuit, they define themselves as a not-for-profit journalism organization whose mission is to focus on investigating and exposing corruption, dishonesty, self-dealing, waste, fraud, and other misconduct in both public and private institutions to achieve a more ethical and transparent society, which I think is probably a mission statement that many news organizations could adopt comfortably. They go on to call their band of what they call guerrilla journalists. They say they work undercover and enlist the help of knowledgeable insiders as sources. And they use those people to get audio and video evidence that shows irrefutable proof of wrongdoing. They have a whole list of their so-called successes. You're probably familiar with many of them. They talk about their core values as being moral courage, leadership, collaboration, and they say, truth is paramount. We will never deceive our audience. We do not distort the facts. We do not selectively edit. Certainly the Washington Post experience with them back in 2017 and that of many other news organizations might suggest to the contrary. They're also very proud of the fact that their website features a mistakes section. And if I can share my screen here just for a minute, I want to show you what it looks like today. These are the mistakes that Project Veritas has made. And as you can see, one of them was settling the lawsuit that was brought against them by Acorn. Another one was pleading guilty to a misdemeanor. This question of whether they improperly edited the video about NPR and its fundraising, a factual correction. Project Veritas said that William Romero was not a US citizen, but it turns out, in fact, he was. I don't know how most news organizations would regard that, but in their complaint, they go on to talk about how most news organizations, in their view, basically hide their mistakes from the public by very opaque corrections and retractions, and that they are much better than that. The other thing, their news gathering techniques aside, the other issue here is that they have become very rampant in their filing of defamation suits. There was one against the New York Times that was heard in the Westchester County Supreme Court back earlier this year. And one of the questions there had to do with the opinion privilege and so forth. I'll leave it to the libel panels to talk about this, but I just want to mention that the judge said that if a journalist interjects an opinion in a news article, he or she has an obligation to alert the reader because a reasonable reader would assume that a journalist is conveying facts, not opinion. I think, what we're seeing with these things is kind of a whole new way of framing the question of who's the media. And if you look at not only that suit, but many other suits, you can see that many of these groups are essentially arguing that every news organization by its very nature is biased and partisan, and that it's just fine that they are too, because that's what the mainstream media are all about. Another thing I wanted to mention briefly, and I don't want to take up too much time, there's a lawsuit pending in the Ninth Circuit, Planned Parenthood versus the Center for Medical Progress. I'm sure you remember how they've gotten into trouble because of their undercover recordings of Planned Parenthood. They're facing felony charges and so forth. Justin Marceau asked members of the FELN if they would join an amicus brief in support of neither party in this case. And I think there were maybe 5 or 6 of us that did sign on to it. And it discussed the importance of undercover reporting for investigative journalism and argued that the First Amendment protects false statements that are used in the course of investigations to gain access. And what's more, that the First Amendment limits recoverable damages for non-defamation claims that arise out of investigative reporting, citing the Food Lion case. And made, I think, a really good argument about the fact that when it's basically just an end run against defamation, it raises serious First Amendment issues. Plus, it argued that news organizations could have to spend an awful lot of money and time to fight off these kinds of cases. So I think there's a fair question here about whether this brief or the reporting by news organizations have threaded the needle here. Because one of the things the amicus brief dwelt on was the notion that journalists have ethical standards, whether they're using the Society of Professional Journalists, or they have their own internal standards, and essentially we can be distinguished from groups like the Center for Medical Progress and for Project Veritas. But even though that distinction is clear to us, I'm not sure that it's necessarily clear to judges, as an example from Judge Wood's opinion would indicate. And I think the litigious nature of these organizations, I would say, also sets them apart from the mainstream media. It reminded me of an old case from 1994 when the author Dan Moldea sued the New York Times for a book review. And I remember he came in when I was still at the Reporters Committee to talk to me about that. And I said, Dan, there's a real problem with journalists filing libel suits. And he said, but I was defamed and they're hurting my reputation and I ought to be able to do this. And of course, it turned out that he was not ultimately successful in that suit. But I think we have to recognize that these organizations see this kind of litigation against their competitors, or it's even those who criticize them, as a very powerful weapon. And that, if nothing else, I think separates them from mainstream media.
Yeah, thanks. I think that's super helpful. The ways that the dots are connected here between this panel and the panel that's happening later on, the defamation, disinformation intersections, I think is really fascinating, right? If you're an organization that straddles the line between what Emily's thinking of as journalism and not journalism, and is working very hard to take advantage of aspects of your investigative agenda to describe yourself as journalism, and then you get labeled as disinformation and you sue for defamation for that label, we suddenly see the through line between a bunch of these issues in ways that seem really worthy of our attention. Adam, I want to give you a chance to chime in for just a minute here, because some of your investigative work on this is the source of much of what we've learned about these sorts of groups. What insights from your reporting do you have on maybe sort of this wider journalism, not journalism concept that Emily's outlined?
You know, we're sort of talking about PV on the macro level. Let's get a little micro here, because my colleague and I spent months and months investigating Project Veritas, and I encourage everybody to read our stories, okay, to give you a sense about, is this a journalism outfit? And when you get into the nitty gritty of their operations and who's running it, it's unlike any journalism outfit I've ever seen, right? The head of, the essentially field operations was a former MI6 spy, right? They use false identities, hidden cameras, and microphones to conduct sting operations. We acquire documents that show the extent that this MI6 spy, his name is Richard Seddon, built espionage tactics in the training for the group's operatives, teaching them to use deception to secure information from potential targets. A couple other notes, one role-playing exercise involved a trainee being interrogated by a law enforcement officer and having to, quote, defend their cover and avoid exciting the officer. Another exercise instructs trainees in how to target a person in an elevator. The students were encouraged to think of their targets as a possible future access agent, potential donor, support, facilities agent. Okay, and we published all of this. Does this sound like a journalism outfit to you? Is that how I conduct journalism? No, I say I'm Adam Goldman. I'm a reporter with the New York Times. I'm working on a story. Would you like to talk to me? Right. And, that's, they defend their tactics as, they call this a long, basically they work in the long tradition of undercover muckraking journalism. And they like to cite that. So, we really, part of the issue, putting Project Veritas aside, is, we have hyper-partisan outfits that are masquerading as news organizations, and there's no transparency. We don't know who's behind them. I can name any number one of blogs that information gets circulated on Facebook and Twitter basically as fact. We don't know who's funding them. They're clearly partisan. They stink of partisanship, right? And, there's no objectivity, and they're not going after both sides. And we have to be able to differentiate. We have to be able to differentiate that. And, I believe in the case of Project Veritas, I think in a lawsuit concerning Democracy Partners, I believe they, in fact, at one point tried to fight to keep our stories out of the trial. They don't want the plaintiffs to bring up our stories, because the plaintiffs are going to point to our stories and say, look, see what the New York Times has written about you? You're not journalists. Right. And you don't get to use that defense. So, ultimately, though, we, as a news organization, we are not going to be able to devote all our time to investigating these individual outfits. Right. There's not enough time, but there are many of them, and they're basically overwhelming the information ecosystem to get out there.
Yeah. I think, right. I mean, I think the broader point is super important, which is that thinking about sort of large scale definitional structures and tools for making those determinations, I think is sort of on deck as the next steps. Okay, we want to make sure to leave at least a bit of time for questions, but I want to try to round out by thinking about how this all maps onto the hard questions that emerge in the statutory space. I know a lot of people in this conference are involved in some way with the Local Journalism Sustainability Act and the definitional issues that are emerging there. But this has been a legislative question that we've had to tussle with in the past, right, Mickey? I mean, in your years at as counsel for news photographers, what takeaways maybe have you gleaned about how we ought to be speaking to lawmakers about who counts as the press and why, or what counts as the press function and why?
I mean, we're seeing that a lot. A case in particular is in California. So they have a section of their law that gives journalists, and again, trying to define who falls into that category has been extremely difficult, but access to natural disasters, forest fires, that kind of thing. It's basically an assumption of the risk. When they close the area off in California, if you're a duly authorized representative of the news media, the law enforcement is supposed to allow you to cross those police and fire lines and enter that area with the knowledge that, hey, if you get stuck, if the fire shifts, if the earth opens up in front of you, we're not coming to rescue you. You want to go in, you know, it's kind of like being in a war zone. You can go. And so we've also argued that should apply in covering civil unrest. And that hasn't been the case. They've really distinguished that. So last year, the legislature in California picked up SB 629, and it basically extended those things and gave a very, very, very broad definition of the press. It was pretty much almost anybody who wanted to self-identify as being press would get this coverage. And it allowed them to do quite a number of things, including entering police command posts. And the bill actually passed both houses. The governor refused to sign it. And in his message, he talked about that. And as soon as I saw that, I said, this is never going to fly. So now we've got SB 98, which we've worked on with a lot of news organizations and a lot of journalists in California. And they took that language out about command posts. They've kind of narrowed the scope of who is a journalist, although it's still a little bit nebulous, and it's waiting for the governor's signature. So those are the kinds of things, you know, we're seeing. I just wanted to mention, going back in terms of, you know, people that are not doing journalism and how difficult it makes it, not only for journalists, but for the police. So during all of the protests, there were exceptions to the curfew for the press. Pretty much every executive order that set up the curfew had a press exemption on it. And the protesters soon realized that, hey, wait a minute, where maybe on the right to record, that applies to everybody, not just journalists. Sometimes journalists can go beyond police and fire lines that the public can't, but the right to record should apply to everybody. But in terms of exemptions past curfews, so that people started writing press on their shirts, making up credentials that said press, you know, trying to carry equipment that looked like they were press. And one minute they were throwing rocks, and the next minute they were up there with holding their cell phones. And when they got a push, no, I'm press, I'm recording. It made it difficult for journalists who are out there shooting, and all of a sudden the police come in, and there's a bunch of people. Some of them might have been doing things that were illegal. Others were trying to cover them. And they basically, I can't decide in the heat of the moment, so you're all under arrest. And that's a real problem for everybody. And it's something that we're all struggling with. I mean, one of the suggestions that we make when legislators are trying to figure out how do we define press, since pretty much every state has a shield law, it's like, well, go to the definition of who qualifies for that qualified privilege under the shield law. But as we know, many of those shield laws are pretty antiquated, and they have very old definitions that really apply to people that make, you know, their living from it. They've got all these different standards that are, that don't apply now, because as we all know, somebody could be a blogger and could have a greater readership than somebody at a major newspaper. So that's something that I think is at least a starting point to look at. Each state legislature should look at what the definitions are, update them, and then for consistency's sake, relate to those. I mean, it's just a starting point as somewhere to talk about. But I know for a fact that police agencies throughout the country are getting out of the business of issuing press credentials. They don't want to be stuck in the position of deciding who is and who isn't a journalist. Not that journalists want them deciding that either, but it's important when you've got a credential that says the bearer of this credential is entitled to cross police and fire lines. It's got to be something with authority, because otherwise, as I've said, you could just bring a note from your mother that says, here, please let me cross your lines. In New York, which, NYPD has been doing press credentialing for a long while, they threw up their hands. It's now in the mayor's office of media and entertainment. And they're going to be promulgating new rules and doing a whole notice of proposed rulemaking, and we'll see what they come up with. But it's a real problem in terms of trying to figure out that age-old question, who is a journalist?
Right. Yeah. I think Mickey's comments have really tapped into this notion of one of the major things that we're trying to do here, which is preserve that press function of acting as a proxy for the public, right? In public sort of accountability and news gathering. And we've seen over the arc of the First Amendment case law, the ways in which the unwillingness or inability to think about individual press protections gets in the way of some of the accountability and watchdoggery that could and ought to, under the First Amendment, take place. So, we say, if we can't give everybody access to the jails, or can't give everybody access to the border detention facility, then nobody gets access to them. And then that's harmful, objectively harmful to the watchdog function of the First Amendment. And the examples that he's giving really map onto that quite closely. The notion that if nobody crosses the police line, we don't have that kind of direct boots on the ground journalism acting as a proxy for the rest of the people. So thinking about who is the proxy becomes incredibly important and admittedly complicated. I want to make sure that we leave open time for questions, but Emily, I'm going to turn to you to sort of bring us home. I think this is a really great moment to sort of hear your thoughts about these questions that Mickey's been raising about the situations in which definitions would be helpful, and maybe tie them back to the work that you were describing in Tao. Sort of what are your views on how we ought to be thinking about line drawing from the journalistic side, not just from the legal side?
Sure. Well, I mean, it's kind of interesting also listening to this discussion. I come from a very different press culture where some of the things that said about what is and isn't journalism just wouldn't fly. Kind of British tabloids, very, very combative, quite often sort of undercover, use I think what in American journalism would be thought of as quite unethical standards, and yet people kind of are very much considered. So perhaps it's good journalism, bad journalism, and then not journalism is what we should be thinking about. But I was also thinking about how perhaps, in previous times, the Guild would have played a big part in this idea that you have some kind of professional kind of membership or unionization, which applies to freelancers and applies to institutional journalists, where there is a sort of a standard of professional behavior and recognition. That's how credentialing worked for a long time in the UK, as you'd have a press card and it came from your membership of the National Union of Journalists, and they had the right, I think, to refuse people membership. I'm not sure they often did. I think that sort of, we just that the real danger, as Mickey very vividly outlined, is that this is absolutely opening the door to shutting down access to the press, ultimately to anybody, and we see all around the world people governments jumping on this as an opportunity. So I think that we do need professional organization within journalism, we need to rethink the role of organizations like the Guild, or like like the Reporters Committee, like just how we think about our own transparency. I see Dave said in the comments, surely leadership and ownership and funding should be things that we take into account in any kind of definition or credentialing. I think that's true. And, our research is looking at lots of networks of these things where it's literally impossible, sort of about pages will change on a daily basis. It's so hard to find out who's behind these things, where the money is coming from. It can't sit in any sort of definition of being an open press organization at all, even if that's how its content is presenting itself. So I think that we have to sort of, it's not one solution, and I think it has to come from platforms taking definitional categories seriously. I think it comes from professional organizations which support journalists and support good journalism, having standards for membership that can actually then feed into some kind of credentialing, but accessible membership. And I think it's about protecting public interest journalism. That what we're really doing is going from defining this big hopper of the media down to the press, down to public interest news. But I think that we're still facing the biggest threat, which is, in arguing about all this, we open a door that says close the standard rather than open the standard. So in other words, just let's assume that we shouldn't be allowing people access because it is too dangerous, rather than there is a category of professional, good faith, public interest actors that we should. But I think these definitional issues should occupy us sort of much more than they have done. And I think that our past sort of attitude of the great thing about journalism is that anyone can be a journalist is very much out of date now. I think that we do have to sort of be aware that that's exploited by all sorts of things which are not journalism.
Yeah, this panel has done everything that I hoped it would do and so much more, because what I wanted to tackle was the sort of hard questions of what the press function looked like and how we might define the press. And we've layered onto that a real set of, I think, guideposts for the kinds of risks that attend the definitional endeavor, and the kind of hopes that we might have for the definitional endeavor, which I think is a really great set of marching orders for all of the folks who are here at AAC. And I think thinking about this in a really boots on the ground kind of way. We have a few minutes left for questions. So many thanks to everybody on the panel, and I'm hoping we'll get to hear a few more thoughts from them as we listen to some of the questions. Dave, did you want to pipe into us either with your own voice or with other people's voices, the Q&A from the wider audience?
Sure, we do have a number of questions, and if people want to post them, let me just start though and take organizers' prerogative to ask the first one. It just seems like all of the panelists, from one perspective or another, whether it's the reporter's privilege or press access or who's going to get tax benefits, are agreeing that there's some need to define who's the press, something that there has never, I guess, not been consensus about in the past. And one question I have is, how do we do that? Like, do we just wait and let Congress do that? Is there some, who is the best person to do that? And how do you see it coming about? I mean, everybody sees a need for it, but how do you see this playing out?
Well, I don't see a need for it. I mean, I'll push back against that. We've had this weird situation in Minnesota with all these protests and everything, but we've never had credentialing here in the Twin Cities. And this came up back when the Republican National Convention was in St. Paul a number of years ago, because the authorities running the convention said, well, where are your press passes? And we said, oh, I don't have them. That's not what we do. And I'm very anxious about this idea that, well, we need to have professional standards and somebody needs to decide whether someone's allowed to be part of a club. The Society of Professional Journalists in its ethics code talks about the need to call out people that aren't doing good journalism, but they don't say that it's appropriate for them to kick people out or set up a tribunal to sit in judgment of them. We've got enough trouble to deal with courts and legislatures without having to do that. And I'm very reluctant to embrace the idea that, for example, the current commission that was established in Massachusetts to look into news deserts and figure out how best to support the media. That may be a ploy that works in Europe and in other countries that have different traditions. But on the other hand, we've seen, as Emily said, and I think somebody else did too, that these can be used as a cudgel to keep people out, to beat them out of participation. So I don't think it's that easy. The simplest definition that I've ever heard is simply the function of journalism, gathering news and disseminating it to the public. To go beyond that, to me, is very dangerous.
Okay. Yeah, I would just note, Jane, that we historically have had quite specific government regulations, and the example is who was eligible to get newspaper rates from the post office, where there were very detailed regulations. What percentage of your newspaper was advertising? How frequently do you publish? Do you make public who owns you and who the editors are? Anyway, so my point is, and I think I hear what you're saying, but I think there may be different considerations. If Congress is about to pass a law saying we're prepared to give tax benefits to organizations that are engaged in local news, there's going to be somebody who decides who gets to do that. Is it the local PTA or is it somebody doing some other function? Anyway, we have a couple of other questions. I didn't mean to monopolize it with that issue. I think it's a serious one. We have a few questions. Let me combine them a couple because I think they're related. One question is particularly to Emily. Your thoughts on are there things we can learn, good or bad, from the approaches that the tech platforms are taking to try to differentiate with algorithms, high quality sources of information from low quality sources of information? And then there's a related one, I think, that I'll just put out because we're short of time, which is when we're defining who's a news organization, how do we account for opinion? In other words, does it have to be unbiased information to qualify as news and journalism?
So taking the second one last, I would say no. I know that very much goes against the norms of American journalism. You absolutely, the establishing that you have to have, a kind of that ship has sailed. So again, you can have partisan journalism, which is of high quality. I think it's just everybody selects their story and their news budget priorities in different ways, and it will vary according to where they sit on the political spectrum. But if they distort or if they deliberately omit publicly available information or very obvious information in order to kind of present a completely wrong story, then that's bad journalism. It's just it's a qualitative question. Can we learn anything from the platforms and their high quality news? No. What we can learn is that they did not really pay enough attention to this categorization and thinking of what they should be circulating on their platforms or what qualities they should put into there. So we should absolutely learn that poor categorization is really damaging. And when it's carried out, by a kind of an authority or a type of law, and I think algorithms are a type of law, which does not have the right inputs, it can be extremely damaging. But it feeds back to this point that you made, Dave, which is, those companies do actually have to put definitions on or labels on certain types of content, certain types of organization, etc., to enable them to make sense of it. The fact they didn't do that is part of the reason we're in such a kind of mess when it comes to thinking about our news environment. The fact that they're doing it now is, kind of, at least it's a band-aid. So I think what we should learn from that is that you can cause damage by doing it badly, and you can cause immense damage by not doing it at all, or at least not having the right transparency into your systems and the ability for people to judge whatever it is they're being told by a series of publicly available bits of information, like where does this website come from, who operates it, etc.
Emily's scholarly agenda, what not to do, right? Journalism, not journalism, how to define, how not to define, the lessons from the paths not traveled. I think that's important.
If anyone else wanted to weigh in on that, lessons, I mean, one thing we didn't talk about that I would just maybe throw out, see if any of the panelists are familiar with what's going on in Europe and the Journalists Trust Initiative, which is another interesting way of trying to deal with some of these issues. It wouldn't get quite to the press pass issue, but it's a program that tries to say we need to have a way to sort out reliable sources of news from unreliable sources of news. And the model, at least to me, the model they're building on is sort of how we accredit colleges in this country. We have independent non-governmental organizations that say you can be accredited if you meet certain standards. You know, how many students and teachers you have, how you pay people, how you evaluate people. It doesn't evaluate the program in the sense of are you Liberty University or are you Goucher College? Schools with different viewpoints and different. That's not part of it. It's evaluating the process and the standards. Do you adhere to certain standards? And you get periodically accredited. And the idea of this Journalism Trust Initiative is to translate that into the world of online news sources. And if you could come up with some set of journalistic standards, do you ever run single source stories without knowing who your source is? And do you give people an opportunity to respond? And do you publicly correct your errors? And a series of standards like that you could then accredit those, have some agency that's non-governmental to review the standards in compliance with the standards and accredit them. And then there's all sorts of things you could do. I mean, that could be a way of qualifying for federal tax benefits. It also, if the platforms wanted to pay along, could be a way for elevating those sources on the internet. It also could be a way of watermarking, so consumers would know when something comes across their Twitter feed if it was a accredited source or not. I mean, it seems like it has a lot of potential, and yet I think everybody here would kind of meet that. Many people here would meet that with some suspicion about, do we want news organizations to be evaluated in any way by an outside organization?
My big concern is for people out on the street, the individual journalists that don't have a news organization. And while I agree with Jane that the definition should be as broad as possible in terms of the intent to gather and disseminate information and for us images, I think it's important to have some way of identifying, as you said, when you've got the press being exempted from a curfew, you've got to be able to identify who's press and who isn't, because if everybody's a journalist, then at the end of the day, nobody's a journalist, and we're all going to be shut out, and they're going to go, this is a worthless exemption, because we have no way of identifying who qualifies for that privilege or who qualifies for a shield law. So it's going to be a struggle. It's not going to be easy, but I think we have to do it ourselves. I'd really prefer the government didn't do it. We saw that struggle during the trying to get a federal shield law. The biggest stumbling block, we were almost there, was how do we define journalists? And we had all kinds of tests, and a number of people proposed things, and there were all these different steps, but there needs to be some mechanism for doing that, because otherwise, whatever legislation gets enacted, if it's too broad, it's going to get struck down as being overly broad. And if it's too narrow, there are going to be far too many people that feel they're left out and don't qualify when they actually should.
We're just about out of time. Any other last minute? Otherwise, I see we're over our time. So I think all that remains has been a great discussion. Thank you all. All that remains is really to give you our gratitude for spending this time with us and sharing your insights. And thank you all. To everyone in the attendance here, we're going to take a little lunch break. We'll be resuming at 1 o'clock with an interesting panel on the rights of protest. It's something that I think that couldn't be more timely. If you think of the rights of protest as a safety valve for greater hostilities and civil tensions, this is really a time when we need to think about how we protect the rights of protest. So I hope you'll join us back here at 1 o'clock. Thanks.